This is Dennis Sullivan. At some time in almost any divorce, the question of whether you can change the locks to the house comes up. Most of the time, the house is considered community property. That means the house is owned by both you and your spouse. When one spouse leaves the house, there are some people who feel that they have the right to change the locks. Unfortunately, while changing the locks may calm your anger or be something that you think can be used against your spouse, the simple fact is that changing of the locks cannot be used to prevent your spouse from accessing the house. In fact, if you change the locks and your spouse breaks in through a door or a window, do not expect your spouse to be arrested. You may find yourself calling 911 if your spouse breaks in, but without any physical threat or physical harm, your spouse is well within their rights to enter their house, even though you may have changed the locks. As a result, changing the locks is usually not a good idea. It's likely to cause more anger and animosity between you and the spouse, cause some unexpected repair bills, and can even be used against you when you're questioned as to the division of assets. However, there are times when changing the locks is called for. If your spouse has been physically abusive to you or your children, or has threatened you or your children, you can seek a protective order from the court, which can bar your spouse from entering the house. If you receive such a protective order, one way of ensuring that your spouse does not violate it would be to change the locks. If your spouse then attempts to break into the house, they would be in violation of the protective order, and police can assist. You can also petition the court for exclusive possession of the house, which, if granted, would allow you the ability to change the locks and bar your spouse from entering. Finally, contrary to what some may believe, the fact of whether a spouse stays in the house or moves does not affect the rights in determining how marital property will be divided. The one issue where the fact of living in the house versus out of the house may arise is in the determination of custody decisions. A court could look at the living arrangements of the spouses in determining custody. While living arrangements may be looked at in determining custody, changing the locks is not a way for you to receive an advantage in the custody decision. In fact, if you change the locks without authority, it could possibly be used against you. The lawyers at Stepp Sullivan are here to help you with any family legal issues you have. We are more than happy to meet with you in person, observing social distancing guidelines, but can also meet with you via Zoom, Skype, or simply over the telephone. If we can answer any questions you have, or if you need any additional information, we're here for you. We work one-on-one with our clients to focus on the outcomes that are most important to you. At Stepp Sullivan, we make it personal, powerful,